Hi, and welcome to today's episode of Real Legal Talk. I'm Joette, and this is Jen. And today's episode is about probate, buying and selling homes that are out of probate. What does that mean, and how do you do it?
So we're going to break our video down into four topics or four issues that you run into when buying or selling a home out of probate. And the first thing to discuss is, what does it mean to be subject to probate? So probate means, or buying a property or selling a property in probate means that the homeowner has passed and either has left a will or has not left a will. And if they have left a will, they've already designated who their executor is going to be, and whether that executor has the power to sell property is one of the things that the executor would have the power to do, or the will would state whether it does. And if the person that has passed away, the homeowner that has passed, did leave a will, it makes the process much simpler because it's already telling you that they can, in fact, sell the property, and the executor can act without needing to seek probate court approval. Now, when the homeowner has not created a will before passing, then it sort of changes the timeline of things.
Makes it much longer.
Right. Now you have the probate court that needs to give the approval for the sale of the property. They need to appoint an administrator or a fiduciary as opposed to one already being selected by the deceased individual. And any changes that are made or any sale prices that are to be agreed upon need to be submitted to the court for approval. So it drags out the time frame a lot longer when someone passes away without a will.
The other thing to note is that if there is no will and the person who is going to be administering the estate applies for probate court approval and even receives probate court approval, that's still not the last step. As a buyer, that doesn't necessarily mean that as soon as the probate court approves the sale, that you can go ahead and close on the home. Under Connecticut state law, there is still a 30-day appeal period after the probate court has approved the sale. So let's say that you want to buy a home and you picked May 1st as your closing date, and the probate attorney didn't submit the documentation for the approval of the sale until April 15th. And let's say the court approved it that day. Just because it was approved on April 15th doesn't mean that you're going to still be able to close on April 15th or even May 1st. You have to wait that full 30-day period to pass. Even though the contract date said May 1st, you have to wait until May 15th, because that's 30 days from the approval date, in order to close on the home. So that's definitely something that you should consider and take into and think about when you're thinking about buying a home out of probate.
The big ticket items to take from what Joette just said are, this is a situation when there's no will.
Right.
So there's no will, you have a 30-day appeal period so that others who may have been potential beneficiaries have the opportunity to come in and appeal the court's order, essentially. So that's with no will, you have that 30-day appeal period. And really, you have to wait that 30 days to protect yourself as a buyer against any other potential parties who may have an interest in the property. So that's why you wouldn't want to close before the 30-day period. And then the other important thing, again, is it changes the timelines of the contract. So no matter what you've agreed to in the contract, you still have these outstanding issues that are going to extend or potentially extend those deadlines. So that's what probate means. That's what being subject to probate means. The second step, or the second issue, is how do we go about getting probate court approval? So in the situation where you don't have a will, what do you do? What do we do to get probate court approval? So when that happens, the court is not really familiar with what the value of your property is, what it should be selling for. So oftentimes they will want to hear from not just the court-appointed fiduciary, but a real estate agent who can give a CMA, which is a market analysis, to say this is what we think the fair market value is of the property. Here are comparables to demonstrate why we think this is the appropriate fair market value. And the court looks at all of that to create a justification. You know, they look at the condition of the property, if there are reasons why this property should sell for a little bit less because of its current state, or because the mechanicals have failed, or because it needs a new roof. So these are all things that the court is going to look at in deciding whether the proposed offer from a potential buyer is worth it, is acceptable. Now keep in mind that everything is going to need to be approved by the probate court. So any changes to that price, and after the inspections, if you have inspection issues and there are credits that are agreed upon, those are all going to need to be resubmitted to the court for their approval.
And again, it's important to note that what Jen just talked about is in the case where there is no will. So if there is a will, then all of these items that we're discussing right now, you can just bypass. And that's why having a will makes things much simpler when it comes to selling real estate out of a probate situation.
Right. And the reason for that is because the will specifically states, this is the person I name as my executor, and this person has the right to engage in the sale of property, the transfer of property, negotiations on my property. So it really already gives the authority. So that person would have their own rights to meet with a real estate agent and make those decisions without the probate court's approval. So that's why it's so important.
Now, whether the situation, whether that person has a will or doesn't have a will when they pass, there is one very important document that you need in order to buy a home or sell a home out of probate. And that document says two things. The first thing is that it says that there are no estate taxes due on the estate of the person who passed away. And second, that all probate court fees have been paid. So it's called a certificate of estate tax lien release. And like I said, it states those two things. That original document will come to you from the probate court, and it needs to be recorded on the land record. So it is a part of the closing process, and it is necessary, or it is preferential rather, to have it prior to closing.
Yeah, I mean, and I would say that you need to have it before closing on a property. But so even if you have your probate court approval without a will, even if you have a will and you don't need probate court approval, as Joette said, this document is the document you need in order to really close. And what you've already gone over what it says, but you need the original. In order to get it, we need to file some tax return forms with the probate court, some other things with the probate court so that they can designate whether it is a taxable estate, for example. And then once they've made those determinations and any fees have been paid, they will issue the original certificate releasing estate tax lien, which needs to be recorded at closing. So once you have that, then you're good to go and you can close on the property. So the fourth and final issue that we'd like to discuss on probate files are things that sellers can be exempt from as part of the probate process. Or if their seller is selling property from an estate, what do they not have to do that an ordinary seller would have to do?
There's two main documents that if you're the executor or administrator of an estate that you do not have to provide to a prospective buyer. The first is a smoke and carbon affidavit. Under state law, it says that typically, as a seller of a home, you provide an affidavit that says there are smoke detectors and carbon monoxide detectors, if applicable, that are in the home and are in working condition, and you sign the affidavit at closing, or you pay $250 to the buyer at the time of closing if you do not want to provide that affidavit. If you're the seller of a probate property, you are exempt from that. So you don't have to provide the affidavit, and you also do not have to provide the $250. The second document is the property condition disclosure. This is the rather lengthy document that has all types of questions about the property, the condition of it, that all sellers are required to provide to buyers. Otherwise, there's a $500 penalty under state law. If you are selling out of a probate property, you do not have to provide it, and you do not have to pay the $500.
That's correct. And that property condition disclosure report is done in the beginning of the transaction. So you know right from the get-go that this seller does not have to give you that information. The smoke and carbon affidavit comes at the time of closing. So
these are all important considerations to know and to think about if you are selling or buying a probate property. If you have any other further questions, contact Jen or myself. We'd be happy to help you.
And it's very important to be working with people who are familiar with this process. So real estate agents and attorneys alike that are familiar with that are very crucial to making it a smooth process for buyers and sellers in this situation. So thank you guys for joining us, and we'll see you next time.
Take care.
Bye.